This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the conviction of a pill mill doctor who insisted on appealing his conviction and why a healthcare fraud conviction was affirmed by the Sixth Circuit Court of Appeal, because acting as Dr. Feelgood is a federal crime. According to the Sixth Circuit, Dr. David Jankowski's medical clinics relied on several unusual billing and prescription practices, many of which were illegal, and Jankowski fraudulently billed Medicare for services he did not provide and prescribed controlled substances to patients whose conditions did not call for such treatment, with some patients unlawfully trafficking their prescribed drugs. In the United States of America versus David Jankowski, M.D., the United States Court of Appeal for the Sixth Circuit, on October 23, 2024, disposed of the fraudster's claims on appeal. Following a trial, Jankowski was convicted of unlawful distribution of controlled substances, healthcare fraud, and conspiracy to commit the two offenses. Jankowski was a licensed physician who specialized in pain management. He possessed a DEA license which allowed him to prescribe and dispense controlled substances. Jankowski offered pain management services through two corporate entities. One operated a clinic equipped with an in-house pharmacy stocked with narcotics and other controlled substances, and another functioned as a home-based healthcare practice that sent providers to patients' homes. Jankowski was eligible to bill the federal Medicare program for these services, and together his companies received $35.3 million in gross proceeds between 2011 and 2018. And over the course of about 6 years, Jankowski and his associates filed more than 3.4 million doses of Schedule 2, 3, and 4 controlled substances. The evidence at trial revealed that Jankowski's operations were rife with impropriety. Jankowski provided patients with unnecessary pain medication. His patients would later resell the pills, with one of Jankowski's patients becoming the biggest pill dealer in the community. Besides seeing patients himself, Jankowski prepared pre-signed prescriptions so that unlicensed employees could prescribe controlled substances improperly in his absence. Jankowski billed Medicare for services he did not provide. Ultimately, 32 counts of various crimes proceeded to trial. The FBI conducted its investigation into Jankowski partly through Henderson Butler, a confidential informant who posed as a patient at Jankowski's clinic while equipped with recording devices. The evidence reflected many irregularities, including the fact that Jankowski did not always consult with Butler, the patient, even though the visits were billed under Jankowski's name. The jury convicted Jankowski of 30 of the 32 counts. The district court imposed forfeiture in the amount of $35 million and sentenced Jankowski to 240 months imprisonment, followed by 3 years of supervised release. Jankowski raised many issues on appeal that the Sixth Circuit disposed of in order. The Sixth Circuit noted that to prove that Jankowski committed healthcare fraud, the government had to prove that 1. He created a scheme or artifice to defraud a healthcare program. 2. implemented the plan, and 3, acted with the intent to defraud. At trial, the government introduced evidence to convince Jankowski of conspiracy to commit healthcare fraud, and the government provided evidence that Jankowski informed his billing company that he always directly supervised mid-level practitioners at his practice, allowing the company to bill under his name for a higher rate. The evidence also showed that Jankowski's practice billed 221 claims to Medicare for services provided while Jankowski was out of state. The statements or lack thereof made by Mr. Butler and the employees did not themselves violate the Confrontation Clause of the United States Constitution, since they were co-conspirators. His big concern, of course, was the $35 million forfeiture order imposed on him based upon health care fraud, and subjected him to a forfeiture penalty of the gross proceeds traceable to the commission of the offense, whether directly or indirectly. This is Section 18 U.S.C. Section 982A7. At trial, the government introduced evidence that Jankowski's corporate entities brought in $35.3 million in revenue between 2010 and 2018. Jankowski's fraud scheme centered on his illegal activities and all masquerading as legitimate medical services. The district court concluded that Jankowski's medical practices were tantamount to prescription mills, and from these findings, the $35 million figure represents both direct proceeds of Jankowski's crime as well as indirect proceeds to maintain the fraudulent appearances, and as a conclusion, at the very least, the Sixth Circuit concluded that there was no plain error on the part of the trial court. In my opinion, the doctor and his lawyers who brought this appeal defied chutzpah or unmitigated gall, since he took in more than $35 million individually or through solely owned corporate entities without even providing the services claimed. Not only did he bill for services he did not use or provide, he was the supplier of illegal drugs to drug dealers. As a very bad man and a doctor who did not follow the Hippocratic Oath to first do no harm, instead he profited by doing harm. He will spend the next 250 months in the Federal Gray Bar Hotel. Federal prison is not a retirement place. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. You'll also gain access to more than 4,900 blog postings. You can also subscribe to these videos on rumble.com or youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And please tell your friends and colleagues about these blogs and these videos so that they too can subscribe. And if you're interested in a more detailed information about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.